Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. And by the way, I hope you're enjoying the music in this particular coffee shop. If you can hear it, it does vary depending where I go. However, back to the subject at hand. If you happen to be a minor or you know of a minor who's in the United States illegally, there is a whole plethora of immigration law on what is known as special immigrant juvenile petitions. Now, at first it seems like it's a daunting task to get a SIJ petition through and so forth, but there's actually not that anything in immigration law is easy, but if you know the minor, and essentially the minor's not living with his or her parents, then the issue of special immigrant juvenile petition should come up. And you might want to consider doing this, because once the person passes 18, then this is no longer an option. And keep in mind, that's different than what's referred to as a child in immigration law, where the person actually can remain unmarried and up to 21. So 18 is the cutoff here. Now, there's certain things that need to be done before the person reaches 18. It doesn't mean that you need a final approval from immigration before the person's 18, just certain of the parts that need to be done. So, first of all, in order to get a special immigrant juvenile petition, and this will vary depending what state you live in, because family court is different on every state. It is a different procedure, different codes, different judges, and so forth. It's not all the same, but you need to go into the family court and you need to show that the child is you need to get an order showing that the child is a dependent of the court. Now, some people take this as meaning that the court is going to, basically have to bring the child home with the judge and, have 24/7, authorization to do anything and everything, and that's not the case. This means basically that the juvenile is relying on the court for its rulings. It does not mean a ward of the state. Okay, there's a big difference there. So that's the first order that's needed. Now, in order to go in and do the special immigrant juvenile petition at immigration, you have to have this order of the family court, okay, showing that the juvenile is a dependent of the court. And so you also need to show that the child cannot return to the country of origin, and this is what you have to put in the petition that you are doing to the family court. You show that the child needs to be a dependent of the court, that the child cannot return to the country of origin, and that there has been an abandonment by both parents. Okay, so obviously if they're living with the parents, that's not going to be possible. But assuming that there is an abandonment, there's a whole issue on, in case law and statutes as to what is considered abandonment, but that's for another video. But you show those three things, again, dependent of the court, cannot return to country of origin, and abandoned by both parents. Then you need to get the order. Now, there's, depending on the state, depending on the judge, sometimes it's good to mention the exact reason why you're doing this under immigration law. Sometimes it's not so good and you need to be a little ambiguous. Sometimes it's good just to try to get the order without any periphery information. Sometimes it requires extensive briefing. It depends. So you have to essentially know the family court and decide what the best way is to get this. Now, in regards to this, there are petitions then, once you have that order, that can go forward into immigration in which to show that the person qualifies for a special immigrant juvenile petition, and that's essentially, well, there's some specifics obviously. That person would then file an adjustment of status application in which to adjust status to that of a lawful permanent resident as a special immigrant juvenile. Part of the forms, or one of the forms, has multiple different categories as to eligibility. One of those being, battered spouse, another being religious petition, and so forth. I mean, I could go on with all the different items that this particular form has, but one of them is the special immigrant juvenile petition. And then assuming everything's done correctly, assuming it's all filed and you have the order from the state court and it is timely filed, then when it's approved, if it's approved, then this person, this juvenile, becomes a lawful permanent resident. Now, if the person became a lawful permanent resident under a special immigrant juvenile petition, then that person, that juvenile, can never petition his or her parents. Okay? So, you might have a creative attorney that shows particular abandonment and gets all the orders and finally gets the green card, and then the child gets over 21, ultimately becomes a U.S. citizen, says, well, now I'm going to help my parents again, and petition them. It won't happen. There's no time in that person's life that they can petition their parents after becoming a green card holder on a special immigrant juvenile petition. So keep that in mind so that you don't think in the future that's going to happen. Okay, if you like the video, click like, subscribe, more on the coming videos. Okay, bye.